Hi, this is Lisa Stark. I'm the current vice chair of the editorial board of Business Law Today. I'm here with Tarik Haskins from Morris Nichols. Tarik is one of our managing editors. He is an active member of the ABA and is speaking today at a number of panels. So Tarik, when did you get first involved in the ABA and why?
I got involved probably, I would say, either 2007 or 2008. I think the first meeting I went to was actually in Texas, I believe. It was in Dallas about 10 years ago.
Oh,
and that
wow.
was the first meeting that I went to. One of the reasons I got involved was at the urging of one of the partners in our firm, Rick Alexander, who was very active in the ABA business law section and thought it was a great way to network, obviously learn to practice and learn from basically the greatest minds working in the fields that we work in. So I got involved at that time and sort of haven't looked back. I've been gradually getting more involved in sort of different committees, involved with the UCC Secured Lending Committee, Middle Market Committee, also involved with the M&A Committee, obviously involved with Business Law Today, and basically find all of that stuff very interesting. I mean, it's amazing some of the people that you get to work with and get to meet. Typically, the people who you're talking to at these events are the people who write the treatises that we refer to when we have issues that pop up. So it's been amazing for me, and also to meet all of the people that I've met through this process.
Now, do you hold any leadership positions in any of our committees?
Yep. So and this one is a mouthful, for the Secured Lending Subcommittee of the Commercial Finance Committee, I am currently the chair. My term actually is up after this meeting, but then I'll go on to the programs part of that, which is the leadership portion that is responsible for coming up with all of the programming that Commercial Finance and UCC does as well.
And how do you think being a leader in one of the committees has helped you in your practice of law?
It's been a tremendous help for me. I mean, there's a number of different projects. First of all, from being a leader and being involved in the ABA business law section, you get involved with different task forces. So I've been involved with the revised model asset purchase agreement, with revising that and drafting that document. I've been involved with drafting the model pledge agreement for pledge of LLC interest, been involved with that. And so from the leadership and my involvement in the committee, I'm on the cutting edge. So I can be on deals or deal with deal documents and able to say, hey, this provision is a market, or this is where things are going. And by the way, we're working on a new model agreement that basically lays this out. And I've had to use that trump card a few times just in negotiating with different folks. So I think from that perspective, it's been great. And then also just the folks that you meet. I mean, obviously we practice in Delaware, so we know a lot of the folks in Delaware. And we also know a lot of folks in New York, but through this process, I've been able to make connections with folks in, Utah, Iowa, Arizona, everywhere. Like you said, everywhere. Yeah, international. I mean, a lot of Canadians come. And so then, where an issue comes up and there's something that you need to deal with, you're able to go through your contact list and have somebody there who, maybe you had dinner with them at the last ABA business law section meeting. And that's something you obviously wouldn't get if you're just spending time sort of at your desk or, sort of just watch a program on PLI. You don't get that opportunity to sort of network with different people. And as you build up that network, I think it just helps you become a better lawyer.
Yeah, I mean, that's certainly something I've found that, if you're involved, the ABA is willing to promote and push up those people who work hard. Yeah. When I was a younger lawyer, that was one of those things that we didn't necessarily get all the time as younger lawyers in law firms, some of these experiences. And so certainly being, in committees and speaking and being on in leadership roles, certainly I know helped me personally. Did you find the same thing?
Yeah, no, I think I mean, obviously, from the law firm, you get the opportunity to manage different projects and manage different people, but also here, I mean, with the ABA, you're in a leadership role and you get to sort of hone your management skills.
Oh, yeah.
I mean,
Exactly.
I mean,
You
to
have
be
to
the
herd cattle.
taskmaster, yeah, exactly, and especially here where maybe you don't have the same sort of ways to incentivize people to do what you want when you're at your firm and you have your associates who you're reviewing every
Right,
6 months.
right.
This is a volunteer organization, so when you have these different projects that you have people that are working on it, it takes a different set of skills to try to make sure that we get those things done. But I think you're able to hone those things when you're in these leadership roles. And I think one of the other things that we didn't touch on, but I think it also builds your brand. I mean,
Yeah.
it really does build your brand in terms of people knowing you and building your brand out there. I was working on a deal probably about a summer ago, and it was a deal that involved a master limited partnership. It was a transaction, and we were on the phone with the chairman of the special committee that was created, and he said before he got on, he read one of the articles that I had written on El Paso in Business Law Today, and obviously that's something I wouldn't have written or had published had I not been involved with the ABA, and so I think for that, it gave me credence with this person who was chairman of the special committee that he said, when I Googled, El Paso and special committee, your article came up.
Oh, well, yeah, I mean, that's a great point. And, I certainly would say the same thing with Business Law Today. For me, in terms of plugging, I wrote an article probably 7 years ago about MAC clauses. I have gotten calls in the last 6 years from the Financial Times, because we've obviously have a lot of MAC cases in Delaware. The Financial Times and several other news outlets like, oh, we just read your article. It's really relevant. Would you be willing to give a quote or help me understand this? I'm just a reporter, so that's a great point and another reason to get involved with, particularly in writing with Business Law Today. If you like to write as well, the other thing about the ABA is obviously they have things for everybody with different skill sets. I mean, if you're we have the task forces where there's usually some sort of publication or product that's being produced, and there are other committees and so forth that focus on different skill sets, I think. So there's something for everything. So you're going to be talking on a panel tomorrow that's being sponsored by the Private Equity and Venture Capital Committee. So I wanted to talk about that panel a little bit. So that the program is I think it's called Why Should Private Equity Take Another Look at LLCs? So what was the idea for this program, and tell us a little bit about it.
Yeah, no problem. So I think this was the brainchild of the private equity subcommittee. Obviously, one of the things that they look at is venture capital and how venture capital raised capital and how they invested. In looking at sort of the business model for venture capital, that they want to invest funds into an emerging and growing company and then exit that investment in 5 to 8 years. There were a few cases that came out over the past 5 or 7 years where the investments were made into Delaware corporations, and the objectives of the venture capital investors in terms of getting out in 5 to 8 years weren't necessarily, they didn't satisfy their objectives there because they had certain fiduciary duties that would require them to either stay in those investments a little bit longer, make sure that they would get more funds in any sort of exit transaction to make sure that the common stockholders would have something.
Right. Corporations are supposed to be run for the interests of the long-term equity holders, and I think that's a big problem for private equity investors because they want to get in and get out.
Yeah, exactly. Their whole model is to make an investment in a company that's growing, and so they're not taking funds out. There's no distributions, there's no interest, and so the only way they make money is when they exit. And so that's key to them, and I mean it's their whole business model. But a lot of times, because of the fiduciary duties that either the board of directors have, or if they're a controlling stockholder, the fiduciary duties that they have to worry about, okay, there's an exit transaction that I have here. That's great for me, but the common stockholders may not be able to get anything. And then you're in a situation where, because of fiduciary duties, possibly the venture capital firm will not be able to take advantage of that. That's a situation that you can contract around in the LLC world, and so that's sort of the genesis for the program, looking at LLCs and whether or not LLCs may be a better path for VCs. And if you think about sort of what their business objective is if they want to exit in 5 to 8 years based on sort of their terms and what's best for the VCs at that time, and not having to worry about, okay, the founders or the common stockholders, are they getting enough in this deal? Those are things that you can contract around in the LLC world, and so that's why we're saying take another look at it. So.
Okay, yeah. So essentially, if you're a manager of an LLC, you can essentially, I think what you're saying is you can say that in your agreement that the manager doesn't owe fiduciary duties to the members or any other person who's bound by the agreement. Now, there's this little caveat that says you can't eliminate the implied covenant in good faith and fair dealing. So what's the implied covenant?
Yeah.
We see that as corporate lawyers and corporations. A lot of cases lately, it's one of the hottest topics. Sort of, it has its limitations.
Yeah.
And tell me a little bit about the implied covenant.
Well, the implied covenant is an evolving tool, but the implied covenant is basically a covenant that is in every contract. Uh-huh. So when you enter into any contract, be it an LLC agreement, a limited partnership agreement, or a merger agreement, there's an implied covenant of good faith and fair dealing. And essentially what that means is that there's an implied covenant in here that the parties to the agreement will not do something that's arbitrary or capricious, or do something that's going to make the other counterparty not receive the benefit of their bargain. That's sort of easy to say just in layman's,
right.
just to sort of say it, but in practice it's sort of hard to do. But the way that the courts have tried to apply it is basically it's a 2 or 3 step process. And the first thing they look at is they say that the implied covenant should only be used if there's a gap in the contract. So they look at the contract to see if there are any terms that speak to whatever the issue is. So if there's an issue in terms of how you sell a company, does the LLC agreement actually speak to that? And if the LLC agreement says how you sell the agreement, then there's no gap for the implied covenant to fill. But to the extent the LLC agreement does not fill that gap, and there's some gap in there, there's still the second step that you have to go to. And that second step says that the Delaware courts will not sort of rewrite the contract. So they'll try to look at the entire contract and see if the parties would have thought about this gap. Does the contract speak to how they would have determined that?
Right.
So you try to look at the terms in the contract and say, okay, based on everything in this contract, it's very clear how these parties would have agreed to handle this. And that's really hard in practice because
hard, yeah.
I mean it's trying to, and this is at the time of entering into the contract, so you have to go back to 4 or 5 years ago,
right.
whenever they drafted this, to figure out, okay, if the parties had really sat down and thought about this issue, how would they resolve it? One other caveat to that, it also typically has to be an issue that they could not have anticipated.
Right.
So it also has to be something that nobody even thought about. If it's something that they could have thought about, or something that people had thought about but just didn't address, the implied covenant still doesn't apply there. So like I said, it applies in all contracts, but in the LLC and LP realm, it gets a lot of traction there. You see it used a lot. Because like we said, you can waive fiduciary duties. So if you're a minority stockholder and you waive fiduciary duties, if something goes wrong, there's some self-dealing, all you're left with is an implied covenant claim. And so that's what we see in a lot of these cases where the LLC has waived fiduciary duties and you have a plaintiff's attorney who, obviously there's something that went wrong, there was some interested transaction, and the only thing they're left with is the implied covenant, which is traditionally, it has been a very hard claim to make, and I think it's still a hard claim, but you see sort of, from the time that I started doing this, where the implied covenant was almost never successful.
Right.
It never survived the motion to dismiss. Sort of with the complexion of the courts changing a little bit, you see the court a little bit more receptive to implied covenant claims, but it is still a very tough road to go.
Yeah, it's essentially when I don't know if you probably find the same thing when I'm talking to people about the implied covenant, they always, their sort of hope is that the implied covenant means that everybody had to act in good faith.
Yeah.
And that's not what the implied covenant
Not
means.
at all. Not at all. So I mean, that's a good point. I mean, people hear the implied covenant of good faith and fair dealing, but that good faith only applies to good faith. You have to act in good faith and stay in good faith with respect to the application of that contract. It's not a free-floating form of duty of good faith. it's faith to the terms of that contract. So whatever the terms of the contract are, you have to make sure your actions are consistent with this. But it certainly isn't sort of a resubstitution of some sort of free-floating good faith standard. And that's one thing that the courts have said, that the implied covenant will not be used to reintroduce sort of
New
fiduciary
terms.
duty review or anything like that. And particularly in the LOC and LP range, the chancellors and the Court of Chancery have said that where fiduciary duties have been waived, the court should be even more leery to use the implied covenant, because there the parties have basically indicated that whatever losses are going to result should fall wherever they should fall, and the court shouldn't come in and sort of try to reintroduce some sort of fiduciary duty review.
Okay. Yeah, that came up recently in the Miller case. What happened there?
Yeah, that was an interesting case. So, the Miller versus HCP case was a case of a situation that we see often. It was a company that was doing okay but wasn't doing great. A VC firm had made an investment. In that investment, they were a Series D and Series E investment. And pursuant to that investment, they received a right to 200% return on their capital, and they would get that return before anybody else got anything. So the Series B, Series A, and Common would not receive anything unless the Series D and E received funds. So essentially, I think it was something about 90% of the first proceeds would go to the Series D and E, and nothing else would go to the common. In addition, in that LOC agreement, they waived fiduciary duties completely. And they also had a covenant in there that basically provided that the board of directors could cause a sale of the company in its sole discretion, so long as it was to an independent third party. So, I mean, sort of not surprising to anyone else. The Series D and Series E investors came with a transaction that they wanted to enter into, and this transaction was a transaction whereby they would receive their return, they would get their 200% return, but the Series A and B common wouldn't get anything. So they wanted to do this transaction, and sort of long story short, they ended up consummating that transaction over the objections of the common and the founder. The common and the founder actually wanted them to sort of shop the deal, which here they didn't. They just came to the board and said, we're going to sell the company in 2017, first quarter in 2017, which was 3 or 4 months later. The founders and the rest of the board were extraordinarily surprised that this was coming about, and begged them for an opportunity to be able to run a process and see if they could get a better deal, which the venture capital investors sort of gave them an opportunity, gave them 5 days.
Oh, 5 days to find another deal?
5 days to go find another deal. But certainly they weren't open to an open market process. So they had the 5 days to go try to find a deal, and they actually did find someone who was interested in providing a at least an indication of interest at a better deal than what the VC firm had. I think it was about $9 or $10 million more. But the VC firm wasn't really interested in facilitating that transaction. Which, arguably you can sort of see why they had a sure deal lined up. And this one was just an indication of interest.
Nobody had done any due diligence.
No due diligence. You don't know how creditworthy the party was. So they said, thanks, but no thanks. We have this deal, and we're going to end up doing this deal. So they end up doing that deal, and afterwards the plaintiffs were to claim for implied covenant of good faith and fair dealing. Typically, if this was a corporation, that would be a fiduciary duty claim. You would certainly bring a fiduciary duty claim. But here, because all fiduciary duties were waived, all you had was implied covenant claim. And there, Glasscock basically looked at the facts and looked at a waiver of fiduciary duties, a very clear covenant to be able to sell the company in the sole discretion, and said that there was no gap in the contract. From the plaintiff's perspective, they tried to argue that there was a gap because the way they viewed the covenant only said that the board had the discretion to determine whether or not the sale would be a merger or sale of assets. It was a very tortured reading that they proffered, but they said that whether or not to sell in the open market was not up to them. It was up to reasonable discretion. So they said there was a gap there. Glasscock disagreed with that, said that it was very clear that the sole discretion was as to the merger and also to the process. There was no sort of restriction on those things. And then the other thing that they tried to argue is that the implied covenant created a gap because the implied covenant also will apply where one party has discretion. And that party has discretion, and the contract doesn't say what sort of discretion it is, should be sole and absolute. Sometimes the implied covenant is used in that instance. And so in this case, the plaintiffs tried to argue that there was a need for the implied covenant because there was a sole discretion standard where the implied covenant need to fill in. And there was some case law that says even if you do have sole discretion, the courts will apply the implied covenant.
Okay.
But it's a narrow band of cases where you can apply it to sole discretion if there's a chance for self-interest. So if there's a chance that that sole discretion will be used solely for your self-interest, then the implied covenant will come in to sort of save the day and sort of modify that discretion. But here, Glasscock said there was no gap because here the sole discretion was also limited that any sale had to be to a third party. So he said that they thought about it and resolved that they could protect themselves by providing this this transaction would have to be to a third party. So he said that there was no gap. So essentially what you had is an LLC where the VC firm had its exit, it had its objective, it wanted to get out. It did not want to wait until it could get a deal that would sort of provide funds sufficient enough to flow down to the lower tiers, and because of the contractual arrangement that it had in the LLC agreement, it was confirmed. It was okay. Glasscock said, nope, no problem here. It goes through, it sails through. Not to belabor the point too much, but obviously it was appeal because that was sort of it was a difficult pill to swallow for the shareholders. And my understanding is that there were oral arguments on that case yesterday, and apparently, at least based on some of the reporting, I haven't seen the hearing. At least some of the justices seemed sympathetic to the plaintiff's claim. So. More on that to come.
More on that to come, but it sounds like there's a good reason for VC investors to consider using LLCs as a form. I mean, I know it is sometimes difficult because they're used to the corporate form, and a lot of times that's really the reason that they choose using a corporation. But as you've just explained today, there are a lot of reasons to use the LLC as the form. So, in a parting question, I just wanted to ask you what your advice is for young lawyers who are thinking about getting involved with the ABA and about coming to meetings and that kind of stuff. Do you recommend it to young lawyers out there?
Certainly, I would certainly recommend it. I think there's definitely a value to it. I mean, I think there's a value to it that can't be obtained, as I said, from just sort of watching a webcast or listening into a webinar at your desk. I mean, I think there's a benefit to coming here and meeting people and sort of, I mean, it's funny, you sort of grow up with some of these lawyers that you meet. I mean, when you come, you sort of sometimes gravitate to people.
We have a taxi cab relationship. I mean, the only time we see each other, although we live in the same town, is the taxi ride from the airport. Yeah, exactly.
But you definitely, you see the same folks every year and year after year, and you evolve. You start out as an associate, they become partners, and then all of a sudden you have this growing list of contacts, partners throughout the country. So there's certainly benefits in that way, but also I think the other thing is the information is just cutting edge. I mean, the information that you get here is tremendous. I mean, when you go to the programming, you always learn something, and you're learning from the best folks who are doing it, and you're learning from folks who are, basically you're going to be reading books and treatises, and people are going to be citing to some of the things that they're talking about in years to come in cases. And the last thing that I'll say is you certainly get an opportunity to work on stuff. I mean, I think getting involved with the task forces are just great. Like some of the drafting. They need
grunt work, and that's perfect for a younger assistant.
Right? I mean, there's grunt work, but then there's also so much learning.
Right, and a chance to rise and grow. And as we talked about earlier, that ABA offers so much opportunity to start and grow and learn and eventually become a leader. So thank you so much, Tarik, for doing this interview today.